Good afternoon. Thank you for joining us on this webinar today about OSHA inspections and drones. The use of drones brings up some very interesting concepts that we need to discuss. So the man behind the voice you're hearing is Carl Habekost. I'm an attorney with the law firm of Bugbee and Conkle. I head up the labor and employment section. I have always had an interest in safety, flowing from workers' compensation to violation of specific safety requirements to OSHA, and trying to make sure that employers have a safe workplace. With us today, we're glad to have Professor Donald Ellswick. Professor, are you on the line?
Yeah, and just wanted to tell everyone, thanks again for joining us. Carl and I are both excited about presenting this really innovative way to inspect your site. And I think you'll walk out of it with some information that will not only help you today, but in the future. So thanks, Carl, for allowing me to join you.
No, it's a pleasure. We feel we're lucky. Here's what we're going to do today. We are going to address what a standard inspection by OSHA looks like. Some tips that you need to follow, and that puts in context then this new and innovative way of inspecting a work site by OSHA using drones, otherwise known as unmanned air flight systems. Okay, let's get going, Carrie. I always like to remind people that you control your own work site. You need to be proactive in safety matters. Develop and practice your written safety programs, because if you don't do it, OSHA is going to do it for you. So it's mandatory that you monitor and maintain a safe workplace, because I'm telling you, if you don't do it, OSHA is going to do it for you, and it may not look like the way that you want it to look like. Okay, let's move through the OSHA inspection process. We're going to talk about what OSHA looks for when they come to inspect your place, what are some of their priorities, how you can prepare for an inspection, and then what the actual process is. Professor Ellswick, anytime you want to chime in, feel free. You've actually been in plants where OSHA has come knocking on the door, and so you probably have some insider recommendations for our attendees today. What OSHA really focuses on immediately when they walk in the door, does management care about maintaining a safe workplace, and are the employees involved in that process? They will want to see whether or not you have analyzed potential hazards, whether you've done worksite analysis, whether you're educating your employees, and also training and documenting the training. As we've said many times, if you don't have documentation, as far as any federal agency is concerned, it didn't happen.
And Carl, it's a good breaking point to kind of talk to people. And one of the things Carl and I like to say, we know we've got about 12 participants with us today. The other thing we want to look at for you 12 is take this information and share it with your employees. I always say to my students, especially your first day on the job, you get to know the receptionist. That's one of the 5 important people you need to meet your first day, because what's going to happen to her, this friendly compliance, safety, and health officer known as a COSHO is going to come in, potentially flash a badge at her and introduce herself in a very, very calm way. However, unless your employees are educated, trained, and they understand your commitment, it could start off very badly. So everything Carl's sharing with you today, you want to take back and share with your employees.
Excellent. Excellent point, Professor. Well, there's something known as weighted inspections. OSHA has, go back, no, that's okay. I kind of skipped a slide, but we'll get to weighted inspections later on then. Here's what OSHA is looking at. Imminent danger. In other words, they want to try to get there and make sure that a fatality or catastrophe does not happen. So imminent danger is the highest priority for OSHA. Then you can see on the screen, fatality and catastrophe is next. Complaints by employees. We see a lot of complaints by employees that result in inspections. I would also note, along with the complaints by employees, OSHA has an entire process where they'll come out and inspect, depending on the facts and circumstances. When employers call in and report, as you know, there is a requirement for employers to report certain types of injuries, amputations, loss of an eye, hospitalization. So OSHA has an entire grid that they analyze to determine whether or not to come out and do an inspection. We've done webinars on that. It's called the Rapid, I forget what it is. It's RRI, Rapid Response Investigation. Do you have any other comments on that, Professor?
No, and especially, guys, one of the things I'll say, especially with your serious injury and fatality or your SIF incidents where you have one of the criteria where you're going to be subject to an inspection, think about the story you're going to tell. Think about why the incident happened. Look at the human factors. Look at organizational, which are really tough because you're pointing the finger at yourself, and also look at your equipment. So be prepared when OSHA comes in, especially on the rapid investigation reports or the RIRs you're sending back, that you understand what you're sending to OSHA, because that's all about painting the picture and the story of what you want OSHA to know. So you're right on, Carl.
Very good. I jumped a slide a little early, weighted inspections, and perhaps, Professor, you could comment on this. It's a newer analysis that OSHA is using for their compliance officers.
And let me say, if you're in the region, and I'm going to assume most of you are on the East Coast or in the Ohio area, what they're trying to do, because we all know OSHA does not have enough inspectors, they're trying to go toward enforcement that really identifies their targeted programs. And we all know that's the forklift, the energy control, lockout, tagout, the elevated work. And, as you're looking at those inspections, confined spaces included too, that's where your priority should be, because when they come in particular, and some people work in PSM, which is another targeted inspection, they're going to come in and look around for those items first. So it's a good way for you to be prepared and even prepare your managers for them to come in.
Excellent. Thank you. Well, the inspection. You need to be prepared, as Professor Ellswick just said. It's amazing to me that in today's age, I still have employers call up and say, somebody from OSHA came, they presented what looked like an ID. We weren't sure who should follow them around, so we just basically said, come and talk to us if you have any questions. And that's a real live story from one of our files, where a couple of years ago, an employer literally allowed a compliance officer to just walk around the plant for 2 days. So you need to have an inspection team, and you need to have backup. Who's going to be on the team? Why are they going to be on the team? Perhaps you have one safety person, and if that person is on vacation or they're out sick, who is going to deal with OSHA when they come to the door? How is the receptionist going to treat OSHA? Do you have any sort of procedure when OSHA comes knocking on the door? And do you have your tape measure, cameras? Do you have a checklist of what needs to be done prior to allowing the compliance officer into your place of business?
And I wanted to add too, and I know Carl and I talked about this, we get questions all the time about what should you have in your kit? Well, there's a simple, I'm going to mention a few things you may not think about. You know, have a spare as far as, I know we all carry cameras, but make sure you have extra batteries or a charger, something if you need extra memory, you've got that. Also have communication, so throughout your walkthrough you have that. I encourage people, if you're not going to allow the inspector into an area for their safety, have binoculars. You know, make sure you've got an area, a safe area where your classification allows you to use smartphones, tablets, laptops. And then the other thing, make sure you have, you know, if you have cameras, things like that, make sure they're in good condition too. So just wanted to toss that out too on that inspection box. Make sure you've got spares and extras, Carl.
Sure, it's the old Scout motto, be prepared. Or risk management. Things happen that you don't expect, so you have to be prepared on how to handle that. OSHA has the right to come in without unreasonable delay and at a reasonable time. Well, what is an unreasonable delay? Most of the compliance officers that I've spoken to, at any rate, do not want to wait around longer than an hour. If you have a very reasonable explanation for why they should be delayed further, then they might work with you, but an hour, 2 hours at most is what I would call a reasonable delay. They also, you can limit their inspection during regular working hours. So you're not obligated to open the plant or open your business at midnight just to accommodate them. But I doubt that you would have to do that anyway because they're government employees and they have specific working hours, and overtime is not always authorized. This brings up an interesting case. I put more on the slide than normal just to let you know. This case came out about a year and a half ago, and it is significant because of the fact that OSHA's search warrant was quashed. That means it was basically wiped out. The facts are that there was an arc flash injury, kind of bad burns, and as I indicated earlier, the employer was obligated to call and report that accident to OSHA because the employee was hospitalized. OSHA then came and they requested to perform a comprehensive inspection of the entire facility and not limited to only the electrical accident area. The employer objected to that comprehensive inspection, but they did agree to allow OSHA to come in and inspect only the area where the injury occurred. OSHA also reviewed the 300 logs, and then based upon its review of the 300 injury logs, OSHA sought a judicial warrant. Their main point was that these injury logs revealed all sorts of problems in unsafe work environments. And as far as OSHA was concerned, those OSHA 300 logs revealed violation of safety regulations. The company objected to the warrant, went before a magistrate. The magistrate said initially, yes, you know, this is a good search warrant. The district court judge who reviewed the employer's arguments, said, you know what? OSHA doesn't have probable cause to search the entire plant. They have probable cause to search the electrical accident area and some machine guarding issues. And of course, they also have probable cause to look at the injury records. Now, probable cause, the reason this is important, under the United States Constitution, private citizens, and that includes the ownership of private property, have a right to be protected against unreasonable searches and seizures by the government. OSHA is a government agency. So this private employer, Marjack Poultry, exercised their Fourth Amendment rights under the Constitution. And the reason I'm bringing that out, when we get to the drone inspections towards the end of our presentation, the right against unreasonable searches, the plain view doctrine, and looking at everything in your facility becomes important. Anything else you want to touch base on this, Don? I didn't want to drag it out too long.
No, and just so you guys know, there used to be, and this is an old school theory, that you never wanted to ask the OSHA compliance and safety health officer to get a warrant. I will tell you, in discussions with a couple of area directors and even some cause shows, obviously it's, if you need that time to prepare and you need to get an attorney, it's a good way to have them go out. And as Carl mentioned, it's a great way to really limit what they're doing. So I say this, 20 years ago, we used to say, never make them go to the trouble of getting a warrant. Quite frankly, situation by situation, I'm starting to see now that it may be a good idea to go that extra step. And it's no problem for them to do that. And you can just tell them, hey, your legal counsel, once you discuss it with them, has recommended that warrant. And I just want you guys to understand this. It's not uncommon. It's not an admission of guilt. It's not even a problem. It's something they'll do quite quickly.
Right. Very good. Well, here's the process. I know we have some experienced people attending the webinar today, so we'll just go through this quickly. The process is there's a greeting and an opening conference. First impressions are important. That's why Professor Ellswick mentioned you need to actually train your people at the front of your place of business. How are they going to react? How will they talk to the OSHA people? Then the compliance officer, and by the way, when we say compliance officer, we mean inspectors. The compliance officers will walk through, they'll do their inspection, and then they will have a closing conference. So that's the basic process. In a little more detail, here's the opening. You're going to greet. This is what we recommend. You make a photocopy of the credentials. Notify all of the appropriate personnel. You should have the OSHA readiness checklist so that everybody knows what they're supposed to do, and they follow the checklist. This is what normally happens in an opening conference. You try to limit the OSHA inspector to the reason why they're there. You make your decision early on whether or not you want to require them to get a search warrant. So do not go any further than the opening conference if you want to require them to have a search warrant. Anything else, Professor, on OSHA logs at this point?
No, and definitely here's one of the things that I used to do, and I think you guys know this. Keep your 5 years of your OSHA log available. And I mean, have them ready so it's not something you've got to scramble through. A lot of us keep our logs electronically. We all know, Murphy's Law is going to hit whenever you actually need those printed out to give to them. You do that. And it's a good time when you present them with the logs. Start your evidence trail for anything you give them. Make sure it's numbered, serialized, so that you know everything they're taking and you've got a record to supply to your attorney too. And it's just a good way to start with that OSHA log.
Correct. One point that I want to emphasize is that from this point forward, everything that you say to the compliance officer can and will be put into his or her report. And that can and will be used in a court case if it goes that far. So be careful what you tell the compliance officer. Do not volunteer anything. You can be friendly, but you don't have to go overboard. In other words, you're not helping the company if you try to volunteer and make their job easier. And we can actually have an entire webinar on that process of what to say and not to say to OSHA personnel. Just remember, anything you say will be put into the file and it can be used against the company.
Yeah, and Carl, a lot of you that have done some work with me have heard my favorite story about the COSHO, or the inspector that came into my facility, didn't think about it. He needed to do a bio break, use the restroom. I sent him into a locker room. When he came out of the locker room, I didn't realize that we had a new person in the facility, and they had used all of our lockout tagout locks and issued them to new plant employees. So think about where you're sending them, even when you're trying to be kind, because as you all know, under the 1910-146, those locks are specialized. So created an issue that I still love. My favorite OSHA inspector had an easy find on me. So just think about those hospitality issues too.
Great. We will provide you, will we carry a copy of our PowerPoint if you need it. This is just a little more detail, what is required and what you do not want to give to OSHA. So let's move on. The compliance officer is going to walk through the plant. Please stay with the inspector at all times. I'm emphasizing that because when we get to the drone to talk about how drones are used by OSHA in the inspection, that's an important concept. How are you going to stay with the drone when it's flying around videoing and taking photos of your facility? But in any normal inspection, you're going to stay with the inspector at all times. Record all comments, take notes, take pictures and videos of exactly what the compliance officer is photographing. You shouldn't have any question on that. The main thing is try to keep them focused to tour the area requested in the opening conference. I've even recommended to clients when an OSHA compliance officer comes in, that you can walk them outside and go through a door that takes them directly to, let's say, a machine that they're concerned about. You do not have to walk them through the plant. It doesn't even have to be convenient. They're used to that. They're accustomed to doing their job, and if you want to make them walk out in the cold or the rain to go through a certain door that limits their ability to view all around the plant, then you do it. You're just doing your job well. Professor, feel free to jump in at any time. Employee interviews, this is what OSHA has the right to do, to interview your employees, the non-management employees, in private, if the employee consents. And the OSHA officer has a right to truthful responses. You as the employer, and we have safety people on the phone call, you're an agent of the employer, and especially if you're a supervisor, anything you say and do can bind the company from a legal perspective. So the employer has the right to participate in non-private employee interviews. You have the right to end the interview if you want to. Interestingly, the employee has the right to refuse to be interviewed. I've not run into this, but then OSHA has the opportunity to subpoena that employee to interview the employee. But your employees need to know that if they don't want to talk to OSHA, they don't have to. However, you do not want to discriminate or in any way harass or make your employees feel uncomfortable if they do talk to OSHA. Do you have anything further to add on that point, Professor?
Yeah, this is one of those tough areas Carl hit as a whistleblower. And remember, as a whistleblower, it's the perception of the employee. I had a client that basically had an employee that talked to OSHA. There was some overtime assigned a couple of weeks later. They had to go outside their normal policy because there were some accommodations that had been made to the employee that normally was selected. And this was non-occupational accommodations that the employee had decided. They picked the employee that had been interviewed by OSHA. The long and short of it, that employee felt that they were being discriminated against. So I remind employers, when someone talks to OSHA, remind them, hey, if you have a perception or you feel like we're doing something in retaliation, come to us first. Because again, if they go straight to OSHA, they have that right. You don't want to discourage that, but tell them we want a safe and healthful workplace. We want to make sure you understand that we do not want you to feel impeded to talk to OSHA. We want you to talk to OSHA. So again, perception is reality.
Yeah, and that's a hot topic, so that's why we were emphasizing that at this point. So once the compliance officer goes through and they do whatever interviews they may have, they request the documents, there will be a closing conference. It's not often anymore that they have the closing conference right away that day. More and more, I'm seeing that the closing conference consists of a phone call by the compliance officer to usually somebody in management, such as the safety director or the HR manager or someone in that capacity. Is that what you're seeing, Professor?
Yeah, definitely. And the thing, this is a government process, and what will frustrate your management, it flows at what I call a government rate. And that rate is sometimes like molasses, as we all know, very slow and somewhat frustrating. So warn your management team and warn your employees that sometimes those closing, inspection, and even when the cost show finishes, he may give you hints what he's going to do, but it may take time to go through that. So be patient.
It's like walking through a jar of peanut butter. At this point, because we've talked about OSHA logs, I just want to touch base real quickly on recording and record keeping. This is probably the most often asked question that I get on a daily basis. Is this recordable? Should it be recorded? Companies like to avoid having recordable injuries because it does affect their experience rating. And for construction companies, it might even affect their ability to bid on jobs. But that said, you need to record injuries and illnesses that are work-related and meet certain criteria. And I know that having Professor Ellswick as a client many years ago, this is a pet area for him on what should be recorded and what should not be recorded. Professor, you want to talk? We have about 2 or 3 slides here. And this,
let me go ahead and hit that then, and let me tell you guys, and most of you have realized this, this is one of those areas I always say, do a good recordability analysis. I always look at it, if it's within, we all know the 11 reasons that first aid treatment, if it's not listed as that first aid, default to where it's recordable. Now, as soon as I say that, everybody's going to jump up and say, well, there's this exemption. Well, if it's not one of the 11 first aid treatments, you need to definitely document it. If you look at the slide, it's a great representation when we put this together. Any cases that can be work related, basically caused by the work environment. And when the cases are even contributed, let's say someone has a work injury and all of a sudden they're working and their injury is aggravated, that's also, and again, they've done a good job on the slide. We've given you that 1904 5B2 reference. And I just always like to say, look at that. Even sometimes it won't make sense, but make sure you're looking at the regulations. I always point out to clients, and Carl and I both recommend, if you're not going to record it, justify why you're not. And it's not, well, this is ridiculous. Go to the regulations, get help, have someone else look at that. Go ahead and hit the next slide, Carrie. And the other thing, we all know this, and we wanted to just remind you, the severity of a work injury will sometimes necessitate immediate reporting. And we know the death is the 8-hour notification. Again, loss of consciousness is just recorded on your log. You need to know your days away from work. Also, you need to be aware of activities where you're restricting the job. And again, that routine functions, we all know that definition is a task that they do once a week, can fall into that. And then, of course, understanding that first aid treatment that we talked about. Anything outside of that is considered medical treatment. So, you know, I call it the magic pixie dust. If someone sprinkles magic pixie dust on them, well, when you go into the regs and you say, guess what? That magical pixie dust is not listed as first aid. Guess what? That's recordable. So, Carl, I'll let you take over from here, sir.
Sure. Thanks. And before I think we're about ready to get into the drones now that we have a context for this new way of inspection. I simply wanted to point out that recording an incident on an OSHA log does not mean that there was fault, that the employer was at fault, that the employee was at fault. It doesn't even mean that an OSHA regulation has been violated. In fact, that Marjack case that I talked about early on, Marjack Poultry, where we were talking about search warrants and disputing OSHA, the court cited 29 CFR Part 1904 because OSHA was trying to argue that the information on the OSHA 300 logs meant that hazards were in the workplace and that therefore there was probable cause for a search warrant. And that simply is not the case. So if you feel as if the OSHA compliance officer is using that information and finding or citing you for a violation of a regulation because it's on the OSHA logs, that is not legally correct. And I just wanted to emphasize that. Anything further, Professor, before we dive into the drones?
No, and I think we're going great with it. Here's what most of you are going to do. And Carl, I know as we talk about the unmanned aerial vehicles or the UAS program, definitely this is a good topic for you to take to your management team or your safety and health team and really consider what will we do on this. And again, the memorandum Carl's going to go through with us will give you some great guidance. So go ahead, Carl.
All right. OSHA and drones. This is a brand new area for OSHA, and there are more questions than answers. But we thought this is a good opportunity to just throw it out there. We have experienced people attending today. I think we have a graduate student at the University of Cincinnati Environmental Health and Safety Program listening as well. So if you have any questions, please feel free to, or comments, put them in the chat box. And if this is your opportunity, we can talk about it as much as we can in this format. OSHA and drones. Well, you may be surprised that this memorandum has been around for over a year. Memorandum was issued, through the Deputy Assistant Secretary on May 18th, 2018. And the subject is titled OSHA's Use of Unmanned Aircraft Systems in Inspections, otherwise known as UAS or drones. In this memorandum, OSHA has indicated that drones can be used to collect evidence during inspections in certain workplace settings. Mainly that is going to be in an area that is difficult for a human being to inspect, a confined space. And I know, Professor, you've heard people talk anyway about drones being used in confined space, maybe high up on the edge.
Let me hit this, Carl, because with the confined, here's a great, people ask, where are drones used? I actually had a client, and if we know the hierarchy of controls, we all as EHS professionals want to eliminate the hazard. One of our highest risks is entering a confined space, especially a large tank, to do inspections, especially visual. Yeah, and these drones can go in and do really good inspections in the tank. So drones are coming in for use, and I think part of what we're going to talk about today is using them safely, not doing risk shifting where we avoid one hazard and go to another, and the agency kind of talked about that. So people ask me, well, this drones, it's almost like something in the future. No, quite frankly, it'll be things we'll be dealing with even more over 5 years. So thanks, Carl. Great.
Sure. And this is a policy memorandum. This is not the law. This is OSHA's position at this point in time. So keep that in mind as we move along talking about this innovative way of inspecting. The memorandum specifically states that drones may be used for technical assistance in emergencies. That's not defined. You can come up with whatever concept or idea or definition you have for an emergency. But mainly, the purpose of this memorandum is to talk about drones being used during compliance activities. I thought it was interesting. I don't know why, when I was putting together this slide, that to try to give you a concept or an idea of how big these drones are. We have seen drones that are very little. I mean, I'm not much bigger than your cell phone. Drones can also be quite large. So it really depends on the area that the drone is going to be used in. Obviously, you're going to have a small drone that may not be shaped like an airplane that would go into a confined space. If you're going to be flying over a rooftop or a large building or a large area, then you'll have a different kind of drone that will be bigger. So much for the actual memorandum. Now, and I believe, Professor, chime in if you know this, but I believe our region here in Ohio and the region that comes out of Chicago for OSHA, federal OSHA anyway, I believe that we do have an unmanned systems program.
Yeah, Region 5 has, as Carl indicated, just so you guys and everyone understands, they have not used them, I don't think, in Northwest Ohio. Well, there were some plans maybe to do it, but throughout Region 5, or as Carl indicated, in the Chicago regional administrator has indicated he's used drones for inspections. And again, one of the biggest things that I hope you get out of this seminar is think about how you're going to use them, and definitely reach out to legal counsel and make sure they're restricted to where you're going on. Two reasons. Number one, for your protection from illegal. Number two, you need to communicate to your employees, because again, the employees are going to see these drones flying over, and quite frankly, employees may not think it's a regulatory body. I have heard of HR incidents being created where the employee thought the employer was doing surveillance on them. So it's just a good idea to communicate that throughout.
Right. And the important point on this slide is two points. There is a program manager for the region that oversees the drone program. And at the bottom of the slide, the policy as it is currently, OSHA has to obtain express consent from the employer prior to using a drone for any inspection. We'll talk about that in a few minutes in more depth. There's a pre-flight operations. This is important for you as the employer and any of the safety people on the webinar, because they have to have a flight plan and a checklist. Why is that important to you? Well, wouldn't you want to know what they're going to be doing? Don't you want to know where they're going? As Professor Ellswick said, you have employees out there. They need to know what's going on. You don't want this drone flying around all over the place, perhaps looking at patented processes or trademark information that has nothing to do with why the drones are being used. So there is a flight plan. There is a visual observer who must be an OSHA employee. The visual observer is really there to make sure that he or she maintains visual contact with the drone as well as the operator of the drone. So,
thing I wanted to hit with Carl too, just as we were talking through this, you need to kind of during the pre-flight operations determine how you're going to take the data. And one of the questions, are they going to share the drone feed or the camera information with two devices so you can record it too, so it's not limited to what's on the drone? I know one of the procedures for pre-flight, and I had a client that was going to do this. This was a large chemical plant. They literally had a second drone flying right along recording their own data because it was not feasible. They have OSHA turn over their data. They did not want to. So again, this pre-flight is very important. And as Carl indicated, this is where you want to spend the majority of your time preparing.
Absolutely. In fact, there's in the memorandum, there's also a post-flight procedures, and that's where they copy all the data to a CD or any other sort of suitable media. I call it a thumb drive. What's it called, Carrie? All things, okay. But the main thing is they're going to collect and preserve that data from the flight. And as we talked about in the normal inspection process, you always want to have someone following along, the compliance officer, and taking pictures and video, the same thing that the OSHA officer is doing. How are you going to do that when they're flying a drone around? Why is that important? Because OSHA is not going to give you that information willingly. The only way they're going to give that to you is if you're in a court case and you're in the legal process and you have submitted a request for production of documents, then they have to give it to you. But until that time, they're not willingly giving that to you. So here are some points that Professor Ellswick has brought up and that I sort of put on this slide for discussion. Currently, the memorandum on drones indicates that the drones can only be used when there is express consent from the employer. As Professor Ellswick and I have emphasized, this is a policy decision. It is not a regulation. It is not in the statute. It is not the law. Policy decisions can be changed or they can be ignored. Now, for the old timers here, I'm sure you remember for years and years and years, even in the compliance officer manual, the issue of repeat citations, there was a look-back limitation. I believe it was 5 years. And there was a case that came out I think it was 2016 range, where OSHA decided they weren't going to follow their own policy for look-back for repeat citations, and they went back beyond the 5-year period of time. And the court said, you know what, that's just a policy. That's not codified in any legal manner. So if OSHA wants to change the policy, they can do it. Well, they can do the same thing on this express consent from the employer. And that's why we should be talking about drones and how employers are going to handle this. Because it's always possible that OSHA could just get a drone and fly it over your workplace without your express consent. And what are you going to do about it? How are you going to be prepared to handle that? At this point, the memorandum does not provide any requirement for OSHA to share the flight plan with employers. So at this point, I keep emphasizing at this point, before you give consent to OSHA to use a drone, you should say, I will give you consent as long as you give me a copy of the flight plan. What do you think, Professor? Is that a good idea?
And the other thing with that too, you guys know this, it's all about partnering, and you need to remind OSHA, this is not something that you're doing lightly. You have your own policies and procedures, and remember, a safety culture is built on trust, and your employees, you want to build that trust to tell them, because again, a lot of people are not used to having objects flying over their head, very few of us, and that potentially could create an issue where an employee is not paying attention to a life-critical procedure, and you could hurt them. And again, these are things you need to raise with OSHA. A lot of people think, well, they'll think we're hiding something. No, make sure that you tell them why you want this. And it's all about, you know, the general duty clause, providing that safe and healthful workplace. Great point, Carl.
Yeah, absolutely. I think we were talking before the webinar today. What if you have a chemical stored somewhere? You need to know where that drone is flying, because what if it malfunctioned? I mean, things happen, and the drone crashed into volatile chemicals causing a vapor fume or a vapor cloud that could be hazardous. So you need to know that information.
And that's a good thing to remind your emergency responders. As Carl said, that's part of that pre-planning. Hey, we're doing the what-if drills are invaluable. So what Carl just brought up, you as the employer need to do. So great point, Carl.
Sure. Now, there is something called the plain view doctrine. Just going to bring that up to remind people that OSHA has the right to inspect without consent anything that they can see in plain view. That's why roofing companies are always of concern if you're operating a roofing company, because everything you do is in public view. It's plain view. And so if an inspector is walking down the sidewalk and they look over at your facility just as the public, and in plain view they see what is an obvious safety regulation violation, they can use that information to issue a citation. The concern with drones is that they're flying over your facility, and the plain view doctrine is expanded tremendously. So it's gone from something that a human being can view while standing on the ground to everything that a bird can see while it's flying over your facility. That is a concern, and that's why we believe that getting express consent from the employer to limit this somewhat is important from a legal perspective. Now, you always have the safety perspective. You need to know where the drone is flying. You need to be concerned about wires, telephone towers, chemical facilities. But just from a legal perspective, drones can really expand on the plain view doctrine. The other concern from a legal perspective are trade secrets that you might have, something that you do not want open to the public, and a drone just flying over might see it, and then it becomes part of the record. So we don't really necessarily have answers to the plain view doctrine discussion and the trade secrets discussion, other than the express consent from employers is critical, and you need to know the flight plan of the drone to protect yourself. Do we have any questions, Carrie?
Yes, we have one. Are they intrinsically safe drones that are being used in the mentioned tanks?
Professor, did you hear the question? The question is, are they intrinsically safe drones that are being used in the tanks?
So here's on the tank, and for a lot of people on here, they actually did a tank sheet where they opened up the tank a little bit larger, made a larger entry, and it created even a non-confined space entry for the tank sheet. In the one case that I have seen another drone, they actually had to ensure the environment was suitable by doing, your normal gas monitoring the entire flight operation. So quite frankly, it's a great point. Obviously, as we said, you don't want to risk shift that over. There are intrinsically safe drones. I've seen one, that company that had them, but it's a great question to ask to make sure they're safe. More importantly, is the camera that's on the drone intrinsically safe? And that's a little bit tougher to answer too. But yeah, you can get them that way. Again, to me, it's always better to prep things so you don't need that intrinsically safe. But if you have your classification set there, you will have to do it. Which, by the way, Carl, also leads in why the pre-plan is so important. You don't want a drone that is not intrinsically safe flying through a classified area. So great question, whoever hit it.
There we go. Go ahead and shoot any questions you have to me, and I'll make sure Professor Ellswick gets involved as well. Professor, anything else you want to?
Yeah, thanks again for joining us. Again, if there's any areas we can help you in, Carl and I learn from you guys and vice versa. So please send us your email. And I want to give Carrie a big shout out as the production managers. You all know Carl nor I are that talented. Thank goodness Carrie keeps us in line. So thank you all for your time.
All right. Thank you.